what Jennifer would have mentioned had she been with us is that the first step really is to evaluate whether or not you want or need to value your business. How to get it in order so that when you do think about an exit, you have a coherent business to present to a buyer that's organized so that the flow of information is quick and the buyer doesn't lose interest. From my perspective, once the valuation has been done, I sort of look at it from a little bit of a different slant, and I want to know what's motivating your exit. Maybe it's your age, maybe you're tired, maybe you want a succession plan. What are your goals? Are they financial? Are they protecting your vision of your business after your exit? And you know what, I'm going to interrupt myself. Speaking of exit, we're aiming to have wound up here by about 9:30. I just want to mention that so people have an idea as to time. Will you be involved in the business after your exit? Will you take on a consulting role? Will you be chairman of the board? And how to get your house in order, basically. How to prepare for the due diligence process that comes into play whenever you have a business up for sale. Then it's a matter of structuring the deal. Is it an asset sale? Is it a share sale? Or a hybrid deal? And I'll touch on the fundamental differences and how they impact the due diligence process. There's the purchase price. How will you be paid, a lump sum, an earnout, and how you can secure ongoing payment obligations from your buyer. The due diligence process is an important piece, and we'll talk about what is it and how it works. The purchase price is often negotiated. The typical heads of negotiation, we'll talk about that, and also whether or not the purchaser assumes any liabilities. What type of back and forth there can be as the due diligence process is completed. Then there's the papering the deal, and that's when lawyers typically start to get involved. The starting point is usually a letter of intent. There's the various conveyancing and ancillary documents, purchase agreement, third-party consents regarding leases, contracts, equipment leases, supplier arrangements, lenders. Will there be a vendor take-back on anything, or the pledge of shares perhaps in a share sale? A promissory note? Will there be any security given? Do you need a bulk sales affidavit or a waiver? What corporate consents and other consents and approvals might you need? Will there be any trademark assignments? Are there any employment agreements? Then for the buyers as well, how are they going to pay for the business? We'll take a very high-level look at bank financing and how the vendor can help the purchaser in that regard. Then there's always the question of when and how to make it public. And then finally, the closing, when you get an email from me, a big red letter saying you are closed, and then you go see Sabina to figure out how to protect all the money that you've made from your sale. So starting to think about the exit. What's motivating the exit? Some people want to start a new venture. Perhaps somebody has simply expressed an interest in buying your business as a going concern, or perhaps you would like to retire. Any number of things can motivate someone at that point. And that ties into the goals that you have. Are they financial? Perhaps you want to have a degree of control over the next generation. Maybe you want to be there to train your successor. Oftentimes we see parents who have children who are involved in the business or who want to be involved in the business, and parents may or may not decide that that's really the best route to go. And all these types of things have to be factored into the decision as to how to structure a deal and how to move forward. Will you be involved in any way once the sale has closed? You can hold a consulting position. You might want to be in an advisory role in the corporation's board of directors or at shareholder meetings. You may be bound by certain non-competition clauses or covenants or non-solicitation covenants. And how does this fit into your own plans for your future? What do you want to do with your life going forward? And then there's the fundamental matter of getting your house in order and what needs to be done to optimize the sale proceeds. Sometimes you may need to build an actual management team, somebody who can help with the transition and can work with the purchaser. You may need to bring on new staff, or to reduce staff, or perhaps close a division. And the valuation process can sort of help guide this as well. So that's where this sort of thinking starts. And all these considerations help form your idea of your ideal purchaser and of your own must-have deal points and how you find your purchaser. You may want to hire a business broker to assist you, or you may go via word of mouth. And it all takes time, and one thing that frequently surprises people is the fact that pre-exit planning can take 2 years or more. There are tax considerations as well. This 2 years is sort of a magic number that fits in both from a valuation standpoint and from the legal standpoint and from the tax standpoint, but it's a recurrent theme. So once you've decided all this, you get to structure the deal. Are you selling assets, or are you selling shares, or are you going to be selling a bit of both? Some fundamental differences among these different ways of selling and how they impact the due diligence process. The asset sale, the corporation is the seller, and it sells its assets. The purchaser can cherry pick the assets that it wants. Liabilities typically remain with the seller, and you usually need a bulk sales affidavit or a waiver thereof. The bulk sales affidavit, for those of you that aren't familiar with it, is a statement of the creditors of the business, because you want not to have the creditors be able to go after the purchaser who has acquired the assets. The share sale, either you or your holding corporation is the seller, and you are divesting yourself of all the assets and the liabilities by the sale of the shares. So you may want to consider or need to consider a pre-closing corporate reorganization for tax purposes or for income splitting purposes. And a hybrid sale is simply a combination of the two. Some purchasers want to buy some assets in order to have a cost base in them, and then they want to buy the rest. They want to allocate the balance of the purchase price to shares. And this is usually a negotiated point between the buyer and the seller. And I'm going to give you a bit of a break from me at the moment and let Sabina speak to the tax implications of an asset sale versus a share sale. And throw in some hybrid if you'd like. To line after, so I don't know if you just want to.
All right, so I'm going to speak. So thank you everyone again for attending, and we're now going to turn to my favorite topic, and not probably yours, which is tax. I've been practicing tax for 15 years, and I focus primarily on structuring and planning for private companies and their shareholders, succession planning, and I'm also certified as a trusted estate practitioner with STEP Canada. So this is my area of interest and expertise, and one of the things that we're going to talk about today is all of the things that go hand in glove with the valuation considerations and with the structuring considerations from a corporate law perspective. You can't really enter into a transaction as significant and as important as the sale of a business or the transition of your business without thinking about the tax implications. So similar to Elizabeth's structure of her presentation, I'm also going to deal with these issues in the course of my presentation. I won't go through them all right now. We'll talk first about whether it is an asset sale or a share sale and the tax considerations that go along with deciding how you want to structure your transaction. So most importantly, we need to remember that a purchase and sale transaction involves three parties, not two. There's the purchaser, the vendor, and the target corporation. And the tax considerations for all three parties are sometimes different. The purchaser generally wants to buy assets. A purchaser wants to buy assets because they want to acquire a cost base in the assets. For example, goodwill, an intangible asset, does not have a cost base if it is sold through the corporation. You acquire a cost base in the shares of the corporation, but not a cost base in the underlying asset. Depending on the type of business, whether it's a manufacturing or another type of operating business as opposed to a services type business, the structure of the deal will potentially be very different from the vendor or the purchaser's point of view. Also, we have to think about the target corporation. Does it have losses? Are the losses something that the purchaser wishes to acquire and preserve and use? Are they going to be carrying on a same or similar business subsequent to the acquisition of the business? So with a share sale, the old maxim is the vendor wants a share sale and the purchaser wants an asset sale. Why does the vendor want a share sale? Because a share sale, if the company qualifies, offers the benefits of the capital gains exemption, which presently is over $800,000 and is indexed annually. It was stuck at $500,000 for many years. It moved up to $750,000. It's now at $800,000 of capital gains that are exempt or sheltered from tax, and it's indexed annually. So it is possible to incrementally get an increase in your capital gains exemption, which can be material. When there is a share sale, there's a lot of things that you have to think about because you're selling the shares of the underlying target corporation. It's important to ensure that we don't trigger a year-end, that we don't trigger an acquisition of control. And then an asset sale, as I've indicated, it permits the purchaser to achieve a step up in the tax basis of the assets, but it avoids a deemed year-end in the corporation. The issue, though, is that there's potential double taxation from the vendor's perspective, because of the corporation is the vendor of the assets, and then the shareholder also has a cost base in the shares of the corporation itself. And so on a disposition of the shares of the corporation, there's potential for double taxation. We'll have tax at the corporate level, and then we'll have tax at the shareholder level. Okay, so we're going on to liabilities, so I'm going to go back to your slides. Yes. Is this it?
I think so. Thank you. So, any questions so far? Comments? Anything? Yes.
Yeah.
Well, when you were listing different asset classes, you didn't cover it specifically, but is there any difference for real estate owned by a corporation type of business?
Real estate is a very interesting and tricky asset to deal with. Real estate owned by a corporation, depending on the number of units of real estate and how they are dealt with, could potentially be considered inventory as opposed to capital property. The proceeds from the sale of real estate, if it's inventory, are regular business income. They're not capital gains, and they're not subject to more favorable tax treatment. When you have the sale of real estate by a corporation, you also have to be careful of recapture. Recapture is if the building has been depreciated, been fully depreciated prior to sale. On a sale, the amount of depreciation that is in excess of the permitted amount is recaptured, brought back into income. When you have a corporation selling real estate, you have the ability to get the benefit of the capital dividend account if you do have the sale of capital property. If it is real estate that has been used in an active business and you're going to replace that real estate with something else, you can possibly take advantage of the replacement property rules to defer the gain. It really depends on the type of real estate, what it's being used for, how many units of real estate you have that are being disposed of, and whether that would be considered income or capital to the vendor.
So on the purchase side, going back more to the deal so from a corporate perspective, fundamentally, how much do you want and how will you be paid? Will it be a lump sum? Will it be an earnout? If it's an earnout, over how long? Will it be a combination? I've seen so many different ways of doing this. I'm working on a transaction now where the lump sum payment due on closing is quite nominal, but then there's an earnout over the next 5 years that the seller is hoping will net him millions. So there's lots and lots of ways of figuring this out. Sometimes there are holdbacks, for example, against possible termination pay of employees that the purchaser acquires and then decides to terminate post-closing. Sometimes the holdbacks can be for undertakings of the vendor regarding future events that have to happen by a certain date. I worked on a deal a couple of years ago in which the purchaser held back funds against municipal approvals that the vendor was to obtain post-closing. And the vendor wasn't able to obtain them either, so the purchaser kind of walked away a little bit ahead of the game on that side. Will the purchaser assume any liabilities of the corporation, and should the purchase price be reduced as a result? The important thing, though, is to keep your personal goals in mind as you consider these questions. There's no right or wrong answer, really. The due diligence process is the opportunity for the purchaser to review the nuts and bolts of the business before committing to the purchase. The results of the purchaser's due diligence investigations can lead to a reduced purchase price, and they can sometimes even kill the deal. Jennifer would have said that you shouldn't underestimate at all the importance of having signed and organized documents, because in that process, an exchange of information and the speed at which it can be exchanged is very important. It keeps the purchaser's faith in the viability of the business higher, and it maintains their interest too, because nobody really wants to see that type of thing lag. In an asset sale, the due diligence really is of the purchased assets. Are they owned free and clear? Are there any encumbrances, anything that has to be discharged? And there's usually always a minute book review. In a share sale, same idea. Are the shares owned free and clear? Are there any options granted on any of the shares? Are there any guarantees, perhaps, that are tied up? The shares are tied up and given as security. There's your usual minute book review. And we also take a look at the material contracts for change of control provisions, for consent provisions, termination clauses, penalty clauses, and these are important. I closed a deal a few months ago where the buyer had inherited a contract with Yellow Pages. And so for a simple website and the right for Yellow Pages to redirect her phone or something like that, she's paying something ridiculous like $6,000 a month, simply because the termination clause did not allow her out of that contract until its renewal date, and the seller had renewed it about 3 weeks prior to the sale. So she's stuck with that. And then this is all something that you have to factor in when you're evaluating the purchase price and how you want to pay and what you want to pay. And in both cases, it's important to review shareholder agreement to determine whether or not it's a unanimous shareholder agreement, to review employment agreements, any intellectual property that may be being acquired, any relevant environmental issues. You may need to have an environmental study done. You may want to have the vendor pay for that. So this is really sort of the exploratory stage. Yes.
You did want an informal, right?
I absolutely encourage it.
Give you a chance to drink some water. Is there any due diligence recommended or prudent on the seller's part with respect to who the buyer is?
That's a fair question. Yes, and it's usually a little bit, it's similar but different. It's usually not as intense. So the typical due diligence on that side would be that the seller would want to know if it's a corporation, that it's duly constituted and still in good standing. So there's searches that can be run, that its articles and bylaws allow it to enter into the transaction. It's not going to be in violation of any agreements that it's entered into, and there's perhaps some warranties in the agreement to that effect. Even in the case of an individual, you want to make sure that they're solvent and able to effect the purchase. And if there's an earnout or payment over time, and the vendor isn't too sure about the purchaser's viability in that regard, then they may want to take some sort of security, like a pledge back of their own shares or something. So there is. We run standard searches, standard corporate searches on all corporate purchasers as well, because you do want to know who your buyer is. You're quite right. And then
What would you say, this is a really difficult question to answer, but due to complications of each deal, but what would you say would be the average time frame for a deal go from start to finish? And I know that's a good
2 years? No.
That long, eh?
It does depend a little bit on the unforeseens, because in just about every deal I've worked on for the past 20 odd years, there's always a thing, right? And the thing always comes up last minute where you don't expect it. I would say, on average, if the parties have a solidly negotiated letter of intent, sort of setting out the terms of their deal, and they agree to the business points, so if you extract from the process how long it takes to get that done, then an average deal can close anywhere between 3 to 6 weeks. I mean, you know, assuming there's responsiveness, assuming the parties are acting in good faith and both of them want to see things happen, and there's no third parties over which you have no control. For example, a landlord may not give their consent in 3 days just because you want or need it that way. If you're dealing with a bank who has to consent to a change of control or evaluate the solvency of the purchaser to make sure the covenants of the business are still okay going forward, that type of time you can't control. But generally, in a collaborative environment, I'd say 3 to 6 weeks.
Letter of intent.
So the letter of intent, and that's my next point, papering the deal, but I'm happy to jump ahead, this is great. Letter of intent really is a short form, sort of point form document that sets out the structure of the deal and the main terms. It can be binding or non-binding. Usually some of the provisions in it are binding, such as you have to keep confidential what you are learning about the business, confidentiality, a no-shop, but otherwise either party can really walk away from it at any point in time. So it enables the purchaser to learn more about the business and for the vendor to learn more about the purchaser and then walk away.
Now, just to qualify that, you're speaking on terms of more sale of a business versus a property and building that the business is operating. But there's a distinction there between a real estate deal and an actual sale of the business.
There is.
So the letter of intent wouldn't necessarily apply
That's
to
right.
the real estate and the building. Say if a vendor was selling the real estate, the land and the building that the business was, the business is going to move, but the land and the building are going to be sold. The letter of intent that would come into play here, per se.
Per se, no, but it could. For example, if the building has tenants, right, and if the buyer wants to know any of the material contracts surrounding it,
It's owner
so if it's owner occupied, then then it would be a different story. There may still be a letter of intent about the terms of payment, but that can also be done in the offer to purchase as well, right? You may not need it there as much because you're buying a different sort of animal.
But would you not want a significant asset like that included in terms of the deal? What was the consideration? Because what if you go from LOI towards closing and never close, and there is a conflict, and what do you have?
Sorry, if you go from the LOI towards closing and you don't close it.
And the buyer claims, and what you have is the intent expressed by the parties in the beginning.
Yes.
If real estate is not covered.
But I think, I mean, it seems to me that you're talking about the real estate being a component of a business being sold, and Greg's talking more about it from the standalone, right? I think there's two different, yeah. But to your
sort of
point,
fishing around for some free advice here for my client who's in that sort of a situation. It seems to me that the time period, the time frame that was outlined by the person who's thinking about buying this property as far exceeds what I would think would be a normal time frame, actually a year. And I think that, but
that's a negotiated point, right?
that's,
It
yeah,
depends
but
how
I
long the
just, I
vendor wants
can't,
to
like,
sit
there's
on
no
tenterhooks.
offers, there's nothing, it's just a verbal type of a setup where, to use that word setup, it's a verbal agreement where, yeah, I'd like to buy buy this and it's gonna prove to me we're interested.
Well, for that you need
However, it's gonna take me a year to do it.
For that, you need my commercial litigation department, which is excellent, because they'll talk to you about the value of a verbal agreement and you know.
There's not much value to it. Sorry, I don't mean to fish around, it's just a.
No,
the
no, it's fine, it's
circumstances
fine, it's good, we wanted interaction, so that's great. So did I answer your question about, yes? So the assumption of liabilities, again, will the purchaser assume any of the existing liabilities, and will the purchase price be reduced accordingly? Now, papering the deal, to get sort of to Greg's point, typically the first step is a confidentiality agreement or non-disclosure agreement, where you say you're not going to share with the rest of the world what you've learned from the seller about their business. Letter of intent, we've touched on, and it allows everybody to walk away if need be. And then you have the conveyancing documents, which actually effect the transfer of ownership. The purchase agreement is the main document, and it sets out the deal in detail, and the vendor's representations and warranties, as well as the purchaser's. Ancillary documents can take any form. They serve to ensure that the terms of the purchase agreement are properly implemented. And there are conveyancing documents, employment agreements, discharges of guarantees, any applicable corporate resolutions, third-party consents, all the things that I sort of touched on before, well, sales affidavit, employment agreements. An important point to, yes?
Before you move ahead, could you just touch upon binding and non-binding letters of intent?
Sure. A binding letter of intent means that every single provision in that document would be binding upon the parties, and the danger there, the thing to watch out for there is not only can that initiate certain tax consequences, but it also means that there's no out for the parties, because in effect the letter of intent says, I want to buy your business for $1 million and I think I'm going to close on August 31st. So you're stuck from a purchaser's and a vendor's perspective. If it's non-binding, usually there are a couple of provisions that are binding, that do oblige the parties to respect them going forward, regardless of what happens. And that would be confidentiality, because the vendor doesn't want to share their innermost secrets with the purchaser and then have the purchaser walk away from the deal and share those secrets with the rest of the world. And no shop, so that the vendor cannot, during the term of the letter of intent, try to find other buyers. But other than that, the deal is really not there, and the parties can walk away, so the purchaser isn't bound if they don't like the results of the due diligence, or if they discover things that just don't sit well with them, or if they themselves are shopping around and find that there's another business in which they would prefer to invest. So you don't usually find some that are completely non-binding. I've seen a couple that are binding, and it's been difficult dealing with them. Usually you see a sort of hybrid type of thing where a couple of clauses are binding if the balance of the document is not.
And that's verbalized.
It's written. It's written. Yeah.
I'm just, sorry, going to touch upon the tax
Yes.
issues with respect to LOIs for a moment. In a share deal, a binding LOI is to be avoided. Again, as Elizabeth said, there are some elements of the letter of intent that are going to be binding, such as the confidentiality provision and so on. When there is a share transaction, there are provisions in the Income Tax Act that provide that when a purchaser has an option or a right to acquire shares of a company, the Income Tax Act deems that option or right to have been exercised. So what that means in English is that if you're buying the shares of a company and you have a binding letter of intent, you can trigger an acquisition of control of the company, notwithstanding that you haven't actually bought the company yet. So what does that mean from the corporation's perspective? The target company will have a deemed year end. There will be an acceleration of the recognition of certain credits. There will also be potentially the acceleration of the realization of losses. So if you're looking to buy a loss co and you have a binding LOI, you've accelerated the realization of those losses. So it's very important in a share deal that you don't trigger an acquisition of control through a binding letter of intent.
And we deal with that by simply saying, with the exception of paragraphs 8 and 17, this letter is non-binding. And that's it.
Elizabeth, did I miss the distinction between a letter of intent and a deal memo, or did you make anything of that?
I didn't touch on that. A letter of intent is, it's almost like it's a prettier document. It actually is a letter generally, and it's written that way. A deal memo is much more a bullet point form of list of really distilling only the business points. Sometimes the parties start with the deal memo because they need to figure out what they're going to do, and burying all that in a purchase agreement is just too hard to think through and define what you really need to look at in terms of the nuggets of the transaction. So sometimes parties will go from a deal memo to a letter of intent and then on. So in employment agreements, an important thing to keep in mind is that the purchaser is a successor employer and inherits all of the employment history of the employees that the purchaser takes on, which means if you have an employee with a 20-year history and that employee, then you then decide to terminate that employee with pay in lieu of notice of termination, you're dealing with a 20-year employee and not simply with a 2 or 3 or 5 month employee dating from the time that you bought the business. And in a share sale, because the corporation really doesn't change, it's just the control of it that changes, the existing corporation continues as an employer and the purchaser still inherits those types of obligations. So we generally encourage new employment agreements, and we put in it language so that the termination of the inherited employee can kind of be capped, that maybe they can, by giving them additional consideration, the purchaser can start afresh and start the clock running fresh from the date of acquisition of the deal.
And that's okay with the labor legislation?
There's tests to be met. We have to give additional consideration, and that there's no real jurisprudence on what that consideration may be. It can be an extra paid day, it can be a signing bonus, it can be something. But the employee has to have some sort of benefit in signing that new employment agreement. So there's ways.
And
yeah.
that's also separate from any union considerations, if there's unions in place.
The unions would be different. I'm talking about not labor, but
Non-union.
employment. Yeah, I'm not talking about a unionized shop. Yeah. Paying for the business, a high-level view of bank financings in a word. Banks tend to lend on a secured basis, and so the buyer may need to provide personal and corporate guarantees. In terms of legal costs, this often surprises people, but the cost of paper, the bank side of the deal, is about $10,000. The bank may require life insurance. It's going to require that leases, if there are any, be in place, and they generally want to see at least a 10-year term. It's best to get this started earlier in the process, sort of upon receipt of your bank's commitment letter, and not let the bank papering sort of trail to the end. And the vendor can help with a take-back mortgage, a pledge of shares, installment payment arrangements. I'm sorry. Making it public. The usual options would be letters to clients or to colleagues or to the staff. And the timing of this is important. You may not want to alert your staff or your clients right away. It really is a business decision. And as well, it's a matter of deciding who within your business you need to take into your confidence and at what stage of the game and how they can help you move the deal forward. And then closing, once all the issues are resolved and the paperwork is signed and you have your money, you have to see Sabina to figure out how to keep as much of it out of the government's hands as possible, and then you have to go to Jordan to figure out how you can spend it all.
All right, so switch back to tax. See, I'm very excited. So we're going to talk a little bit about the tax considerations with respect to both deciding, so we talked about how you're going to decide whether an asset deal and a share deal and tax considerations that go into that. And I'm going to talk a little bit now about the tax considerations with respect to the receipt of the purchase price and how to best deal with that from a tax perspective. So one of the first issues is the allocation of the purchase price. This is relevant in both a share deal and in an asset deal, but it's more relevant in the context of an asset sale because the purchaser and the vendor have to agree to the allocation. And again, as I've indicated, most purchasers want to allocate as much as possible to intangible assets if they are acquiring them, such as goodwill, those that they can amortize over the longest period that will give them the most favorable tax treatment. And purchase price allocation must be done on obviously on an asset by asset basis. In the context of a share transaction, then really it's generally only the allocation of value between different share classes that is relevant. So if you have common shares only, then clearly 100% of the purchase price is allocated to the common shares. If you have common shares and preferred shares, if you have a class of fixed value preferred shares, if the client's done an estate freeze, then the allocation will have to be determined as between the various classes of shares. Now this is something I hear a lot between parties, and it's more common in a non-arm's length and a related party transaction as opposed to an arm's length transaction. But often people say, well, we'll just allocate $1. We can't allocate $1. You may want to allocate $1, but the Income Tax Act has different ideas. And there are provisions in the Income Tax Act that will deem a reallocation of the purchase price to have occurred. And in particular, I wanted to highlight Section 68 of the Income Tax Act. And that requires a reasonable allocation among assets. And it provides for a reallocation where the consideration is not reasonably allocated. So just be mindful that you cannot pick a value that is not supportable and is not reasonable. It will potentially be reallocated. There is a potential to defer the tax bite in terms of the receipt of proceeds on the sale of a business by claiming a reserve. So the provision is Section 41A of the Income Tax Act, and it permits a reserve, which is an amount to be held back and brought into income over a period of time. The maximum period of time for capital property to claim a reserve is 5 years. So that means you bring 1/5 of the proceeds into income annually, and you only pay tax on the amount that's realized. So to the extent that there is a potentially large tax bite that you're potentially facing, then consideration should be given if there is a sale of capital property that a reserve is claimed for the unpaid balance of the purchase price. There is also another reserve permitted under the Income Tax Act under Section 21N on an asset sale if the amount is not due for a period of at least 2 years and is only in respect of any profit from the sale. So this is in the context of an earn-out provision, for example. And that is the next thing that I'm going to talk about. So what is an earn-out? An earn-out, you've probably all seen or heard of the concept of an earn-out, and it's basically a provision in an agreement that provides for a portion of the sale price being determined and is dependent upon potential future earnings. So for example, if you have an earn-out that is under a share sale, then it will receive capital treatment. So again, just to kind of go back to Tax 101 for a minute, capital gains are treated more favorably than income from a business. When you have a capital gain, 50% of the gain is taxable. The other 50%, if it's a corporate vendor, falls into the capital dividend account and can be paid out as a tax-free capital dividend at a later date. And only the 50% of that capital gain is taxable. And that's the same whether it's an individual or a corporation, only 50% of capital gains are taxable. So if you have a share sale and there is an earn-out provision in the share sale, then the proceeds can be treated as capital as opposed to as business income, provided that the vendor and the purchaser are dealing at arm's length. Arm's length means they are not related parties. And the earn-out feature relates to underlying goodwill, the value of which cannot reasonably be expected to be agreed upon at the date of sale. The duration of the sale agreement does not exceed 5 years, and the vendor is a Canadian resident. So if you meet all of these criteria, you can claim capital treatment for earn-out provisions on the sale of shares. Also, if there are payments based on production or use, so you have a sale of a manufacturing business as a going concern and it has a production and use provisions in the sale agreement, then those are treated as income inclusions and do not get treated as proceeds from the sale of the underlying property. I mentioned this earlier in the context of a sale of capital property is the concept of the capital dividend account. This is not a real account, it's a notional account, and it is available to corporations, and it keeps track basically of the tax-free portion of capital gains. So when you have a sale of capital property, 50% of the gain is taxable. The other 50%, the non-taxable portion, falls into what we call the capital dividend account. Again, it's not a real account, it's a notional account. And it is available only to private corporations, so public corporations do not have a CDA. And it includes things like the non-taxable portion of the capital gain, the non-taxable portion from the disposition of eligible capital property, which are intangibles like goodwill. It includes the receipt of a capital dividend from another corporation who wishes to preserve the character of that as a capital dividend, does not pay it out to another shareholder. That remains in the capital dividend account. Also, net proceeds of a life insurance policy fall into the capital dividend account to be paid out tax-free. What's important, the capital dividend account is a tax-free account. Dividends paid out of it are not subject to tax. If there is a sale of shares, it's very important that you do not, as the vending shareholder, give your purchaser a gift of the balance in your capital dividend account. You should clear out your capital dividend account before you sell by paying yourself a tax-free capital dividend.
What would be the advantage of putting the proceeds of a life insurance policy into capital?
It's just where it falls for tax purposes. It's considered to fall into the capital dividend account because it's a tax-free receipt. And it allows you to be paid out of that capital dividend account tax-free. So it's not that there's an advantage,
At all
it's that
times.
that's where it goes. Yes, correct.
The proceeds are tax-free anyway.
Yes, but if the corporation is the beneficiary, then the proceeds fall into the capital dividend account. And, sorry, just with respect to, I can't think of what my third point here is now. I've lost it, I'm sorry, I'll come back to it. It's okay. If I think of it, I'll come back. So, the capital gains exemption. This only applies on a share sale, and it is only available to individuals. So if you have an OpCo-HoldCo structure, a HoldCo cannot sell the shares of OpCo and claim the capital gains exemption. Only an individual or a trust can claim the capital gains exemption. So the capital gains exemption currently is $813,600. As I indicated, it was changed from $750 to $800 2 years ago in that budget, federal budget, and was indexed and is going to continue to be indexed annually. So there are very many technical steps that need to be considered in analyzing whether a corporation qualifies and is eligible for the capital gains exemption, which is why the 2-year period is really very important. And as Elizabeth indicated, it is a magic number, both for tax and for corporate law purposes in terms of structuring the deal and thinking about exiting. So the first step is to determine whether the share is in fact the share of a qualified small business corporation. So in order to claim the capital gains exemption, you must have a share of a qualified small business corporation. And there are 2 tests that are very long and complex, but I will summarize them very briefly for you. So the first is the holding period test, and it is commonly called the 50% test. So there's 2 parts to the holding period test. First of all, the shares must have been owned by the individual or someone related to the individual, so there's an ownership component. And secondly, there is the 50% asset component. So 50% of the assets in the 2 years prior to disposition must have been used principally in an active business carried on primarily in Canada. So all of these words have a meaning for tax purposes. Principally is 50% or more, and so is primarily 50% or more. So for 24 months prior, 50% or more of the assets of the corporation must have been used in an active business carried on in Canada. A passive business will not qualify So an investment business will not qualify in the sense that if it's an investment holdco. Also, in many instances, real estate investments will not qualify. They're deemed by the Income Tax Act to be passive income. There are ways to convert income from real estate rentals and real estate activity to active business income, but you must know that you have to think about that more than 2 years in advance of your sale, because the Income Tax Act deems income from real estate rentals to be passive, not active. And then at the time of disposition, so on the actual date of disposition, the test goes from a 50% test to a 90% test. So at that point, 90% of the assets must be used principally in an active business carried on primarily in Canada. So if you meet all of those 3 tests, congratulations, you can claim the capital gains exemption and shelter $813,000 of your proceeds from tax. Now, if you are lucky enough to have multiple shareholders or to have a family trust as a shareholder of your corporation, and if you've had the foresight to plan the eventual sale or disposition of your corporation, then it is possible to multiply the capital gains exemption. And what do I mean by that? I don't mean that you, individual taxpayer, can get more than one exemption. You're only allowed one. But if you have beneficiaries of a family trust, which is a shareholder of your corporation, each beneficiary of that trust is entitled to a capital gains exemption. So if you have 4 beneficiaries, you have another 4 capital gains exemptions. So it can become material and it can become significant if your business has a value that can benefit from multiple capital gains exemptions. Again, I want to preface all of this with the caveat that the Income Tax Act has many anti-avoidance rules. There's many technical hoops that have to be gone through in order to ensure that all of the pre-sale planning is done well in advance of an actual disposition. The Income Tax Act, for example, contemplates series of transactions and will look back through a series of transactions to see if any of the series of transactions were undertaken in a manner that was intended to reduce or avoid tax. So it's very important that any pre-sale transactions take place well in advance of the 2-year magic number time frame. And quite frankly, it's often important, even from a ongoing business concern perspective, if you have a business that is an operating business and it has creditors in the ordinary course, you probably want to set up your business in order to be able to have an operating company, a holding company, to strip out what we call redundant, non-operating assets on a regular basis up to your holding company so that they're not subject to claims of creditors. So even if you weren't contemplating an eventual sale for many, many years, even just setting up an OpCo, HoldCo structure makes business sense with respect to preserving your assets from claims of creditors, or from, and also the benefit of making sure that your company remains on side for the purpose of the capital gains exemption. So this is a kind of unrelated topic, but I wanted to put it in here because it is relevant. It's relevant in many contexts. So first of all, if you have a binding letter of intent, as we spoke about earlier, then if your purchaser is a non-resident, or if your proposed purchaser is a public corporation, then a binding letter of intent triggers an acquisition of control, as we've discussed, and could potentially cause a loss of CCPC, which is Canadian Controlled Private Corporation. Now, if there is a loss of CCPC status, there are a number of adverse tax consequences that can result. So the first is that you have the loss of the small business deduction, or potentially having to share, if there's an acquisition of control, you're going to have to share the small business deduction between all members of a related group. So that would not be desirable if you want to acquire the shares of a business, and it's important that you have the benefit of all credits of the $500,000 small business deduction, etc. So again, just as we've already discussed, one way to avoid this result is to proceed on the basis of a non-binding letter of intent. Again, it's something that many people don't think about, and why it's very important that the corporate lawyers and the tax lawyers work together in structuring the deal, because often the corporate lawyers may not be aware that there are these tax issues that may arise, and it's important to also ensure that the needs, often when we're working on a deal, we're thinking about both the vendor and the purchaser's intentions and hoping to optimize the results for both. It doesn't serve us acting for one party only not to take into consideration the wishes of the other side, because clearly we want our deal to close. So often we will collaborate with counsel for the other side to ensure that we are structuring the deal in a way that will optimize meet everyone's objectives and optimize their tax treatment. Okay, so I'm just going to run through very quickly some elections that are available. So post-sale, we have a number of elections that usually are filed in the regular course when we are undertaking a deal that can reduce tax. It's important to be aware that these elections exist because otherwise you will end up paying more tax than you otherwise need to. Now there's always HST to think about. I don't like to think about HST, but it does apply. It applies on commercial sales of real estate, by the way. When you have a corporation that is selling a piece of real estate, HST applies. HST applies in more situations than we'd like to think about in the context of regular business transactions. So there is an election. So unless we were selling all or substantially all of the business, or in the language of the Excise Tax Act, making a supply of a business or a part of a business, we would have to charge, and the purchaser would have to pay HST on that transaction. So if there is a supply of a business or a part of a business, which is important, you can sell just a division. As long as you are selling everything that is required to have that division be sold as a going concern, you can file the Section 167 election and not have to charge, and the purchaser not have to pay HST on that transaction. And it is required to be filed by the due date of the purchaser's GST return for the given reporting period. Now, this one is rather technical in the sense that it applies to eligible capital property, which again is, as I've indicated, are intangible assets. So if you're purchasing customer list, if you're purchasing goodwill, that's eligible capital property for tax purposes. So if you, now there was a recent change in the last budget. It's not, there hasn't been a notice of Ways and Means motion come out yet as far as the proposed legislation, but there is in the last budget a proposal to change the way eligible capital property is treated. Basically, when eligible capital property is sold, when goodwill is sold, again, only 50% of the proceeds from a sale of eligible capital property is taxable. However, there's a timing issue, and you cannot declare and pay a capital dividend until after the year end of the corporation. So this election allows you to take that out of the eligible capital pool and realize the disposition as regular capital property and be able to access your capital dividend account sooner. Although it's not available for goodwill. So just to be clear, I'm using goodwill as my example, but in this particular election, it's not available in respect of goodwill. But if you were to buy a customer list, for example, you could claim the election and be able to immediately realize the capital dividend account if you wanted to. You need to make a payment and not have to wait till the year end.
But a capital dividend account is not eligible for a holdco company that is operating.
No, the capital dividend account is the account that holds the proceeds of the non-taxable proceeds of the sale of capital property. You're thinking of the capital gains exemption. The capital gains exemption is not available to a corporation. Capital dividend account only is available to corporations, right? So another election potentially available is the accounts receivable election. This is one that's often overlooked and it's very important. When you're buying a business as a going concern, the accounts receivable election essentially puts the purchaser in the shoes of the vendor with respect to those accounts receivable and allows the purchaser to effectively deal with those debts as though they had incurred them themselves and write them off and be able to claim a reserve for doubtful debts and so on. So it is beneficial to the extent that the AR component of your asset sale is significant. There is a prescribed form, and if you are dealing with an asset deal that has an AR component, make sure that you look to see that Section 22 election is contemplated in your agreement. And finally, just one other thing that I wanted to talk about. We hear a lot about loss code trading. Losses are very important. Everybody wants to acquire losses. Everybody wants to use losses for a number of reasons. One, if you don't use them, they expire. And secondly, if they are acquired in the course of an acquisition of a business, they are available to be used by the purchaser. And so it's very important in that you have an immediate offset of taxable income through the utilization of losses of your target corporation. However, it's very important to ensure that it's structured properly in order to be able to use your losses. So as we talked about in the context of the danger of an acquisition of control, if there is an acquisition of control that's triggered inadvertently, then net capital losses expire and can't be carried forward and used. So that's a big no-no, and clearly not contemplated and not desirable, because you'll lose the availability of net capital losses if you're the purchaser of a target corporation. However, so non-capital losses, so those are losses that can be applied against any business income of the purchaser, and usually what most people want in acquiring a loss code, must be used in a same or similar business in order to be available. Now, there's lots and lots of technical interpretations and jurisprudence on same or similar business and how they can be available and how these losses can be used, because the CRA clearly has an interest in not permitting losses to be used if you don't strictly meet these criteria. So be mindful of the fact that in order to use non-capital losses and apply them against your business income, then you must have a same business carried on in the post-acquisition year, and not only the same business, but there must be a reasonable expectation of profit. And secondly, so both of these must be met, the losses can then be applied only to the extent of income from the same or similar business. So you can't acquire a restaurant and carry on a windsurfing school and apply the losses. It won't qualify. You have to be operating both the same business with a reasonable expectation of profit, and the losses are only available to be applied to business or income, from same or similar business. So then, once we've got all the outstanding issues resolved, the paperwork is signed, and you have your money, you get the email and red letters from Elizabeth and I that says, congratulations, you're closed.
And then turn it over to Jordan to talk about what to do with that money.
Thank you.